this is an opportunity and will remain an opportunity through email, phone, however you'd like to communicate with us to provide feedback to the work of this group. So I just want to hopefully encourage you all to share your thoughts and comments today and in the future. So why are we talking about rape kits and the Attorney General SART, which really was formed to look at the processing and payment of medical forensic exam kits in Wisconsin from start to finish? Well, I think you can see, this is a topic that not only has garnered a lot of attention both here in Wisconsin and nationally in the past and continues to do so. We have, releases earlier this month about the untested kits in Wisconsin, and we'll touch on that a little bit. But we know that that evidence contains important information, and you can see some of the stories we've just put up on the screen about how information and evidence in those kits can lead to perpetrators being held accountable. And we've had cases in Wisconsin where serial offenders have been identified and perhaps could have been identified sooner regarding testing forensic evidence and testing that evidence in those kits. And I think the other piece that is important to put out there is, for victims who have been sexually assaulted and who go to the hospital to have a forensic exam and who want to engage with the criminal justice system, I think this is an opportunity for the system to, respond and to process the evidence and to take that victim who's willing to undergo that exam and to participate in the system for the criminal justice system to say, we're going to respond and we're going to look at the evidence in those cases. So why did the Attorney General's SART team form? Well, I think really to understand that there's many reasons, but one of the predominant reasons stems from a legislative change that happened, I think, now about 3 years ago. And you have this, the statute that's up on the screen right now. It was inserted into the state budget, of all things. Kind of at the last minute, it kind of flew under the radar screen of many groups, including WCASA, that when we were looking at the budget, there was this provision that was contained in the budget that you see here. And I think, it was a situation of certainly a well-meaning, well-intended decision by a legislator or the legislature to include this, yet has some certainly important ramifications. And I think that remains one of the main reasons why this group has formed. And so you can see up here that the statute is talking about sexual assault evidence where no suspect has been identified. And it talks about when a law enforcement agency collects that evidence and the person who committed the sexual assault has not been identified, the agency shall follow those procedures specified in a different statute. And that part that's highlighted in yellow is really what led to the formation of the AG SART, which is that group is going to inform the Department of Justice in coming up with those procedures and those administrative rules.
Yeah, under the under 165.778 and under this 175.405, essentially the Department of Justice is responsible for developing the procedures that will be soon to be specified in 165.77 sub 8. So those are what we would call administrative regulations that will assist all of us in, and especially the agencies, for example, the law enforcement agencies and the crime lab, as well as prosecutors, in sort of picking their way through this, the provisions of this law and figuring out how we can best make it real and make this law work on a very basic level. What happens when law enforcement agencies are asking what happens, what should we be doing with these kits that we have now, what should we be doing in the future when we get kits, where should they go? It's all those technical things that we have to work out, and those include some measure of policy decisions with a small p, kind of how are we going to get this done in the best way possible for victims and survivors, and also for the criminal justice system to make sure that we can do our jobs. So I think that's one of the reasons, that's probably one of the biggest reasons that we formed the AG SART. But it's important to say that we were also at the Department of Justice having conversations with Jackie Kalari Robinson and Ian Henderson and Kitty Smith and all kinds of different people who were people who were giving us input in terms of how important it would be to bring a group like this together.
Right. And one of the things that I think when this provision was put in the budget, without being able to read the minds of the legislators, which obviously is a challenge, I think the focus here is about where no suspect has been identified. And I think there had been some media attention around stranger. I think that really the intent of this was to capture stranger assaults and to ensure that when a sexual assault that's committed by a stranger, that evidence be tested. But what was really fascinating as we went through this process was that while that may have been the intention, that's not exactly what was going to potentially happen in practice. Because when we're talking about, and as we see going forward, what's sometimes referred to as anonymous kits, which I think that term is kind of misleading, but for victims who are uncertain about whether or not they want to have a forensic exam, they want the evidence collected, but unsure about whether they want to participate in the criminal justice system, that when those kits are gathered and obtained and held and transmitted to law enforcement, that this statute, those would look like kits in which a perpetrator has not been identified, because that information will not be anywhere on the kit. And so what we as a group realize is that this statutory provision would potentially mean that those kits would have to be forwarded and tested. And that's really where I think the committee has spent a lot of its time. Audrey talked about Department of Justice being responsible for creating those administrative rules and regulations to carry out what was put into the budget and what you saw in those statutory provisions. In addition to what we've already talked about, we collectively, WCASA, Department of Justice, SANE nurses, were aware that not only provisions regarding anonymous kits or provisions or processing of kits where a victim was uncertain about reporting were an issue statewide, but really that there was issues regarding many, or that there was inconsistencies in many areas regarding processing of forensic evidence. And that really began at where a patient presents. What options were given to a sexual assault victim when they presented at a healthcare facility, and specifically what options about collecting evidence and not wanting to make a report to law enforcement at that time. What options were patients given? What did the kits even look like? What was in the kits was not consistent across the state. And what happened? Where were the kits held? Where were they stored? Where were they sent? And then even billing practices. That we collectively were aware that it could look differently depending on where you were in the state. And so these are things that have also sort of folded into the work of the AG SART. So back in, I think, December of 2012, so nearly 2 years ago, the Attorney General created a statewide group that they called the Attorney General Sexual Assault Response Team, which in many ways mirrors in composition what a community-based SART team would look like, although we're sort of convening around a more narrow issue than many SART teams around the state gather. It's really the model that was utilized in formulating this team. And so the Attorney General convened this group and appointed members, and with the understanding that just like community-based SART teams, a multidisciplinary approach, a multidisciplinary coordinated examination of this process would create probably the most beneficial outcomes. And so right back in, I think, was it 12 or was it I know we say it's 2011.
I think it was just at the end of 2011,
Yeah,
so
right.
we kind of really started meeting in earnest right a month later, which would be 2012.
So you know, this group has been meeting, you know, nearly 2 years or just over 2 years, and you know, we met probably, I think, you know, quarterly roughly in that time period, and the amount of work that's gone into that committee and the amount of really time that was needed to spend processing these issues, I can tell you, was lengthy, but I think was also really necessary to spend that amount of time because of the complexity of these issues. And so you'll see that the members represented some of the 4 key disciplines that you see in community-based SARTs. Medical professionals, that would include STAIN nurses. Jackie Kalaya-Robinson and other STAIN nurses have participated on this. WCASA and some community-based advocacy participants have been participating in this, in the AG SART. Law enforcement and then prosecution systems are all represented on the committee. And because of the importance of testing and storage of these kits, we've had the participation of the crime lab as well. So here you can see the composition of the committee, and that just reflects what we've already talked about in that multidisciplinary composition. And so how did this committee begin its work? Well, you know, we began by identifying some common principles, what we all sort of believe we were here to work on, and some grounding principles that really centered around a desire to support victims of sexual assault and to provide a victim-centered approach, while at the same time creating or reinforcing the notion that holding perpetrators are accountable was also a fundamental goal. And I think that the work of the committee was informed by existing work and protocols and resources that were already in existence at the time that the Attorney General SART convened. And so that victim-centered, offender-focused approach, many of you are familiar with being present in the Wisconsin Sexual Assault or SART team protocol. We also examined the Wisconsin chapter of the International Association of Forensic Nurses, their protocol, existing law enforcement protocols, and then recognizing that Wisconsin is not doing this work alone, that we are not the only community or state in the country examining and grappling with these issues. It was informed by the work of other states, and some members had reached out to, in particular, Virginia. I think the crime lab folks had reached out to them, and you know, as this work has evolved, we're aware that other states have gone certain directions that continue to inform, even as recently as this summer, New Jersey making some changes that I think we continue to be informed by the work ongoing nationally.
We also looked at, just recently, Alameda County in California, I think, because as the issues come up, we look for someone somewhere in the United States that has already dealt with the specific issue, so that we'll talk a little bit later about the untested kits, but I know that the crime lab reached out to the crime lab in Alameda County because they had faced a similar backlog. And you know, so we've been just opening the lines of communication throughout the United States, really, so that we can make sure that we do the best that we can.
So after going through some of those kind of grounding and core principles of the group, we really began looking at, okay, what happens when a sexual assault victim presents at a hospital? What options are they given, and what is going to happen to the collection, or what is going to happen to the forensic evidence? And really, we looked at, before we got to what's going to happen with the forensic evidence, what options do patients have? And what options, when I say patients, right, sexual assault victims have when they present and when they present at a hospital for medical care, which could include, right, the collection of forensic evidence. So we began there, and to try and create a consistent patient experience or a consistent sexual assault victim experience. And we developed, in the lingo algorithm. I think that's the lingo that those in the medical profession use. You know, developing that protocol, that algorithm, whatever you want to call it.
It's kind of like a flow chart.
Right.
I call it a flow chart.
Right. Yes, exactly. Flow chart to really offer that consistent experience. And then what we're going to be talking about, and really hopefully getting input from you all, is developing a consent form with options, particularly for victims who, at the time of having the exam, are unsure or undecided as to whether or not to report to law enforcement. I mean, truth be told, that's really where we spent most of our time. We kind of looked at the options on either side of that, and they became a little, I think, easier in some ways about victims who know what they want at that particular time. But really, this group focused on what do we do with the kits and what information is provided to survivors who are unsure about reporting. And that is that whole anonymous kit language, or that anonymous kit issue that you may hear talked about not only in Wisconsin but nationally. And so here is the algorithm / flow chart that this committee came up with. And Audrey, I know I would say it looks like this should have been so easy to create.
I know.
I mean, the amount of time
it took just
that we
months
spent.
and months of work, and scrapping things, and
Right.
starting with certain things, and then redoing it. And we really did have the benefit of having a lot of healthcare folks at the table to walk us through sort of what was already happening, what was good about what was happening, what was bad about what was happening, and what had to be refined. So do you want to walk through this? Or?
Yeah, I think. So as I mentioned, options 1 and 2, I think, are the more straightforward options. But starting with option 1, that would really be the situation where a victim is coming in, they want medical care, they want to be treated medically, and they do not want to report to law enforcement. And they don't want forensic evidence collected. Really, this is a survivor who's coming in really seeking health care. And recognizing that is a perfectly valid option, and we want to be sure that we know there's a consistent response. So, you know, there would be the medical forensic exam, which is the term that Jackie has kind of drummed in our collective brains about using consistent language. I think is also important because there's a lot of interchanging of words and terms that mean different things. And so this would be a situation, a survivor wants the medical forensic exam, they don't want the evidence collected, and they don't want to report to law enforcement, and that there would not be testing of forensic evidence in that situation. Really, that's a situation where a healthcare-based option. The second option would really be kind of at the opposite end of the spectrum. This would be a situation where a survivor comes in seeking health care, and forensic evidence collection and participation with the with the criminal justice system. So you'd see the options regarding the exam, a report to law enforcement, the kit is collected, the victim is participating in the criminal justice system, that kit would be sent to the crime lab and tested. And then I think lastly, and where a lot of the work was, a lot of the time was spent for the committee, was on option 3, which is the undecided victim, where the victim who wants health care, wants the medical forensic exam, but is unsure and wants the kit collected, but at this point is not sure about whether or not they want to report to law enforcement. And so in option 3, there would be the collection of the kit. The kit would then be sent to the crime lab, and what this committee has currently proposed is that there would be a waiting period of 6 years in which the victim would have that length of time to decide whether or not she or he would like to ultimately report to law enforcement. And so if after 6 years either the victim affirmatively decides not to and communicates that, not to report, or says I don't want, or just that 6 years lapses then the kit would be destroyed. The other option would be that the victim would have that length of time to make a report, and that the kit would be sitting there at the crime lab and could be tested. One of the things that I think is important to note about that is other tests that might be able to be performed at the time of the forensic exam, such as blood and urine tests, would not be able to be gathered at a later date. And that whether or not the kit could be tested does not mean there's going to be a prosecution. I think that's not, people understand that those two things don't necessarily go hand in hand. They may be able to, but one of the things that's important to understand, and Audrey, I'd like you to maybe explain that piece a little bit, but that evidence still could be utilized in other actions, whether it be an offender commitment under Chapter 980 or as other acts evidence, but that there's a possible utility of that evidence beyond whether or not the offender is charged for that case.
So a couple of things about this option 3. If you look at the third square there that says collection of kit, this is one of the very first, I would call, revolutionary things that we did. And this change, the reason that we're recommending this change is because when we went to try to even count up the number of untested kits that exist in our state, it became very clear to us that kits were being stored, shall we say, inconsistently and in unconventional places sometimes. You know, they would be in so-and-so's desk, or they might be in so-and-so's locker, or they might be at law enforcement, but they might be at the hospital. So it just became very clear to us that it would be helpful if we had an administrative regulation, which we're hoping, I mean, of course, none of these things have happened yet. It's important to say these are all recommendations that are going to come out of this committee. What happens then is that they have to be put into administrative regulation form, but there's sort of this intermediate step in which we have to go through, I can't remember the name of the committee, but it's basically the legislature folks, the staffers, and the legislative lawyers at the Capitol, because they have to look at the administrative regs and make sure that they comport or that they accurately reflect the what the legislation intended to do. So we have to come up with our ideas. We have to send it to those folks. Those folks then send it back to the Department of Justice, where we have a special division that will actually draft the administrative regulations, and then those have to be approved. So it's sort of a long process, and we're at the beginning of it. It doesn't seem like the beginning since we've been at it for 2 years, but anyway. So that's the ultimate process. And I just want to say a couple of words, and then I think we'll pause for questions, because I know that this would be a good place to, we don't want to keep going because we have a lot more information and there's going to be questions about this. So let me just say a couple of things. The box that says hospital sends to crime lab. So what that really means is that when the hospital gets this kit, all right, and the kit, there's 3 separate things that can happen to these kits. If you're in option 1, the kit is not collected, it is not tested, it is destroyed or disposed of. Option number 2, the kit is collected, there is full participation, but what that means is, in terms of the physical kit and where it goes, it will go to law enforcement. Law enforcement, then, we have to work with them to figure out, you know, how they are going to transmit it to the crime lab, how and the when and the wherefores. That all has to still get figured out. But what's important to know is that it goes to law enforcement under option 2. Option 3 is completely different. Option 3, the hospitals really, this was the question. The hospitals didn't want to sit on these kits anymore. They don't want to send it to law enforcement, obviously, because the victim doesn't know that whether he or she wants to participate with law enforcement. So we don't want to send it directly to law enforcement. So the question became, where do they go? We had the crime lab on the committee, and we have Brian O'Keefe, who is sort of the head, the administrator over the crime lab, and they agreed that these kits could be sent to the crime lab. Now, we've done a whole lot of work, and we can answer questions if you want, but just know that we've done a lot of work about what that's going to look like, where the victim's name would be or not be on that transmittal, etc. So that kit is going to sit then for up to 6 years. We had huge debates over this, and it's not set in stone, as we say. This is just the point that we're at right now. And partially the reason that it's a longer time period is because of feedback we've already received from folks in the advocacy world, which we truly appreciate, because prosecutors on the thing and some law enforcement agents really wanted to start at 30 days. So we started with a 30-day waiting period. And it's, you know, we weren't all in agreement with that, but the big point they were making and they kept making was that the case just gets worse with time. It does get harder to investigate. It gets harder to prove. It certainly gets much harder to prosecute. And they wanted to be able to communicate that to victims in a way that really underscores the fact that if you come back to us in 5 years or something and we haven't interviewed all the witnesses, many of the witnesses may have disappeared. You know, the crime scene will not be the same. So we really started with 30 days, and then we kept going up because we really felt strongly, the advocacy folks and people representing victims and some of the prosecutors. I mean, you know, it evolved, I should say. The conversation really evolved until we got to 6 years. 6 years is, I believe, is it the longest of any other state. There may be one state that will hold them for longer if this is what we end up doing.
Right, and I think that's a really good description of really the evolution of that wait period. And I know there were a couple questions about the wait period being 6 years. Is that, and that is, that was the question. And there's another question.
Okay, so let's just go through each question.
The next question is, if I understand correctly, option 2 is still getting details worked out as to if the kids go to law enforcement. We are still not clear on where they will be stored, correct?
For option 2, we know they will go to law enforcement. We know that under the statute, law enforcement, if it fits under that statute, 175, which it is very likely it will, they have to forward that to the crime lab. So the question just becomes, how soon does that happen? Those details haven't been worked out. But you are correct. It will go to law enforcement, and law enforcement, I'm not in 99% of the cases is going to send. In fact, we can't think of a case where it wouldn't go to the crime lab for testing.
Okay. And are there other questions at this time? No, it doesn't. It doesn't sound like it, but certainly please type in using the chat with your questions as we're going through this. I knew there were.
And I needed to.
Oh yeah.
Yeah, I'm sorry. I have to talk about that last box. See where it says may or may not be able to prosecute, could use for other purposes. Part of the evolution that we had in convincing some of our other colleagues to extend it to 6 years was that even if we can't use it for prosecution, all right, so let's say that somebody does want to report this to law enforcement and we're in the 6th year, let's say the worst case scenario, you know, the evidence has all disappeared, witnesses have disappeared, and we can't prosecute the case. There is still value and worth and meaning for that victim in terms of reporting this to law enforcement, because even if we can't prosecute that case, the fact that we get it in the system, the fact that we get a report, those things can be used several other ways. If we get another case against this perpetrator, we can use that report from the victim whose case we could not prosecute. We may be able to use that as what we call other act evidence that truly helps us prove the case. And I'm just going to put a little footnote in here that the legislature just recently passed something that makes it much, much easier for prosecutors to use other act evidence in sexual assault cases. So we are going to be using it quite a bit. The other thing is that those reports, we've had cases in which reports that victims have made where the case could not be prosecuted can still be used in a Chapter 980 Or let's say they could be used for, and I'll pause there for a minute and tell you what I mean. Chapter 980 cases against the perpetrator. So we've had a case where the perpetrator was already in prison. And once the victim came forward and wanted the kit tested, the test hit positively with a DNA match on somebody who was already incarcerated on another charge. So what that does, we decided not to prosecute that case for a number of reasons because the evidence had kind of disintegrated over time, if you will. But we were able to use that report and that victim's statement to get the person committed as a sexually violent person under Chapter 980 because the rules for Chapter 980 are different. You get to consider everything the perpetrator has done, and that includes a case that you might not be able to prosecute, but that you might still have that report by the victim that will help those doctors assess whether this person is a sexually violent person. Another use might be probation or parole. If this person has been convicted of something else and is on probation or parole, we may be able to use the report of the victim in terms of giving it to the person who's supervising the perpetrator so that they can increase the rules on this person and really justify it using those reports. Those are just a couple of examples. There are more that we could think of, but I wanted just to make sure that you heard those justifications that we had because we really talked a lot about that even if we can't prosecute, the end-all, be-all of everything in the world, is, as much as I would like to believe it, is not prosecution or conviction. There are so many other things, in the world that could happen as a result of making a police report.
Thanks, Audrey, for offering those clarifications on 2 and 3 and talking about that, the evidence, the other possible uses of the evidence. And I think just back to the waiting period, that was something, one of the things that we, heard anecdotally from the committee, and really in looking at this nationally, the Urban Institute released a really lengthy study about this issue, forensic compliance and storage of kits earlier this year. And their conclusion, and kind of also what we heard anecdotally, is that, victims who are falling under the option 3 cap situation, so the victims who are undecided about reporting, it seems to be a small percentage who ultimately decide to convert, in other words, their case to reporting with law enforcement. Yet I think we thought it was so important, or this committee thought it was so important to wrestle with and struggle with what that wait period time should look like and should be, that gives victims, the most time to really make those decisions, recognizing that, the points Audrey made about the case not getting stronger over time. All those things are true, yet I think it's important to recognize that where this committee has currently landed and the current proposal on that 6-year wait period would be giving survivors time to make decisions, even if ultimately a small percentage do want to engage. Any number greater than 0, in my mind, it's worth it. And so that's where we currently are. You might, yes, there's a question.
No?
Sure.
Okay, our next question is, would report the events of the SA anonymously. They do not wish to give their name. Could healthcare send the kit to the crime lab now? I'll read that again.
Okay.
Would report the events of the sexual assault anonymously. They do not wish to give their name. Could healthcare send the kit to the crime lab now?
So
we can ask for more clarification.
Yeah, I understand.
Okay,
I think that what the question is we had originally started by calling these anonymous kits or anonymous reports. We did go through a long period of time in which we debated whether or not we would be able to submit a kit without the victim's name ever being attached to the kit and test it. What we ultimately decided was, without the name, there's a limit on what we can do. In other words, we couldn't upload, without a report to law enforcement, we can't upload the DNA profile of this perpetrator to the national database. There are a number of very specific and stringent rules about when you can upload something to go into that national database, because of course we don't want people just having their DNA uploaded willy-nilly, because that is something that sticks with you, you know, for life, that your DNA has been uploaded into this kit. So, into this database. So we ultimately, we toyed with a lot of different things, but ultimately Vicki Bean was there. She helped us wade through this because, and I got persuaded eventually, as well as other people on the committee, that what would happen was, in our understanding, if we submit a kit without a victim's name, it will get run one time against the local database in Wisconsin, and that is it. So we have this one shot that it might identify something or someone. The problem with it is, unfortunately, you would still have to load up the victim's DNA, because we have to be able to know which DNA on the samples belongs to the victim, which belongs to the perpetrator. In terms of testing, it would have to be done. And I think the turning point for us was that then the victim would be subjecting him or herself to, the sad part is the defendant's stuff doesn't get uploaded. It just kind of goes in the system. Oh, whoops, we don't get a hit, then it goes away. Unfortunately, the victim's DNA and profile would stay in the system, and any warrants against the victim would pop up. The victim's stuff stays in the system longer, and so if there were any crimes that the victim committed, those would come back to be matched with the victim because we loaded this stuff in. Eventually, the reason that we don't want to do it is because the negative impact on victims outweighed the possibility for getting this one-hit wonder against only our local database. I don't know if, I know it's complex. I'm not even probably articulating it very well.
And I think these questions are really insightful, and I think they hit on the complexity of trying to summarize what this committee has done for you. It's like we've spent meetings on this, just that issue. And I don't know if there's any additional information from the question or.
The rest of the question came through, and apologies for that. So the full question, which makes sense, is hypothetically a SANE program has collected an anonymous kit in which the patient wants the kit forward to law enforcement and would report the events of the sexual assault anonymously. They do not wish to give their name. Could healthcare send the kit to the crime lab now? So that was the full question, and thanks again for that submission.
It sounds like it's the victim wants to report, but to do so under a Jane Doe.
Right.
No. I don't think that.
We can't do it. We could, but it would be, again, the same analysis I just gave, the same problem, that Jane Doe would suffer, we think, more consequences than the perpetrator from doing it that way. And
the minimal benefit,
minimal benefit.
Although one time.
I know.
One time. These are great questions, though.
Yeah.
What else did I want to talk about? So we talked about the waiting period. You might recognize, or 6 years might sound familiar to folks. And certainly something we did look at was the statute of limitations, and that in Wisconsin is the statute of limitations for most felonies. So that was a factor that the committee looked at. And I think New Jersey, just this summer, I mentioned, was one of the states that they settle on, I believe, a 6-year wait period as well. Now, obviously, there are finer details that the committee hasn't discussed regarding what happens in cases where there's a longer statute of limitations. There's more to be worked out for sure, but we just wanted to get this information out to folks, so hopefully they have an understanding of where the committee has landed currently. And again, these things are not cast in stone at this point. And there's another question.
Next question. Should we just be offering option 1 and 2 at this time? Any idea of when 2015 ? This new process will begin?
Oh, well, there currently aren't administrative rules created that sort of codify this? That's a really good question. I don't know if that's coming from, if it's possible to see if that's coming from a nurse. Oh, yeah, okay. I think, obviously that would be something that I know the Department of Justice is providing technical assistance to SANE nurses across the state, and I think that would be a great place to, not to just put that off on DOJ, Audrey, but, but DOJ
no, I
is
know
the one
exactly what you're saying. Yeah.
providing TA to SANE nurse. I'm seeing that's coming from a SANE nurse,
yeah.
and I would encourage you to follow up with
Right.
with DOJ about that question.
I think the bottom line to your question is no, we don't have the administrative regs in place right now, so we do not have this process codified, and right now it's kind of whatever the practice is in your local area. I will say, though, we are moving at speed. We are trying to get this done as soon as possible so that we can offer these possibilities to victims and survivors, and so we can get clarity for law enforcement. We are not dragging our feet, let's put it that way. So yeah, I would say 2015 would be our target.
Okay. Seeing no further questions right now.
But people can always come back to it. If you think of anything, please ask away.
Right, absolutely, right. Not your only opportunity. We recognize right. It's a lot of information to be putting out there, and again, like I said at the beginning, you have my contact information that we're available for further information, whether it's questions or just feedback. But we really want that information. So moving along, would be the consent form.
Right.
And so this, I tried to, I recognize it's, you put these things on as screenshots, and I wanted to capture as much as I could as possible. But the important thing to understand about the consent form is that this is going to be utilized for option statewide, but for option 3.
Correct.
Right, and that this information would be really then important that this would be conveyed to the victims who are in that uncertain place. And so I just want to go through it fairly quickly. Again, you all have the PowerPoint, so it can take time to spend with us after the presentation. But there's some general information about billing at the top and about where to contact DOJ about billing for the forensic exam, and we understand there are federal requirements about that. I want to focus a little more on, although if there are questions about A, please ask, mostly on what's captured under subheading B, the informed consent for medical forensic exam, evidence stored 6 years. And so you can see that the victim or the survivor would be able to check boxes here to say, I'm unsure if I want to report at this time, but I want the exam and I want the evidence collected. And I'm requesting that it be stored for up to 6 years while I make the decision. And then understanding what that means, right? That in this option, your personal identifying. So again, that anonymous, I try not to use that. I recognize that's how it's referred to colloquially or by others nationally, but I'm really trying to avoid using that term because I think it's misleading, and it's misleading for victims for exactly what you see under the first check mark under subheading B, that my personal identifying information will be included with the exam evidence and stored at the crime lab.
It will be inside. It will not be on the outside.
Great point.
So that you see that next checkpoint, my personal identifying information will not be released to law enforcement. So it won't be on the outside. It won't be given to law enforcement. It will be on the inside so that and I think we're going to use barcodes and stickers so that the Department of Justice now, another shift is going to be that we provide all of the kits to the hospitals. They have to use our kits. The kits, I mean, obviously we've done it. We've put them together in collaboration with SANE nurses everywhere, but so there'll be acceptable kits in terms of what's in them. But the purpose really for that is that the Department of Justice can issue barcoded stickers with each kit. So each kit will have its own barcode. My understanding is that that barcode will sticker will then also be placed in the medical record, but the medical record will be the only place, because that is protected by HIPAA. The medical record is the only place that you have the victim's name and that barcode come together, unless and until that kit is opened up. And when the kit is opened up, which would happen only if the victim says that they want to make a report to law enforcement, so they're well aware that once they make that report to law enforcement, their identity is going to be known, then the crime lab will have the victim's name and the barcode also together in one place.
And then the last check mark would be that, right, the crime lab is going to store the evidence for 6 years from the date of an exam. And then other information about, you know, if the victim does want to report that it's their responsibility to do so, and that they would be given contact information. I just wasn't able to capture everything on one screen about where to make a report, and then what the date, what 6 years, what the date is. Oh no, there you do.
Yeah, it's right there. Yeah, it'll be in bold.
Yeah.
The date will be very important, obviously. So that'll be there, and the local law enforcement number that the victim can call to make the report will also be on this form, and the victim will get a copy of this form.
And then C, I think this was something we wanted to really, I mean, I think in many situations and in ideal responses, the advocate will be there, right? We understand what the adult or the SART protocol in many jurisdictions would be that the advocate's there, responds to the hospital when the victim does. Right, I'm not telling you all anything you don't know about that, but recognizing that we want to include the advocacy agency's information there as well. Even if the advocate's there, it's, you know, the victim can take that with them when they leave, and so that they know and are aware of support services in the community. Because if for some reason the advocate isn't there, then that information is provided to the survivor.
Especially because at the point where the survivor is looking at this form and trying to think through their decision as to whether they report to law enforcement, we just felt it was really important that advocacy folks be listed right there, so that when the victim or survivor is thinking about this, they also have the number of somebody who can help them weigh these different options.
With that one.
There's a question.
Okay.
How does the hospital know what the local law enforcement agency?
I'm guessing it's how does they know what the local law enforcement agency is? I mean, that's a really good question.
Yes.
I'm thinking, really, you know,
Well, they're going to have, I would guess, a list of the local law enforcement agencies.
In there.
And when they ask the victim, I know that as part of the SANE exam, the victim describes the incident and where it occurred. And where it occurred is tells you which law enforcement agency is responsible. I don't know. We haven't really investigated what to do if there are questions about that, but I would assume that at the Department of Justice now, since we're doing the SANE nurse trainings and we're doing these regional trainings, that we should include that in the regional trainings. Once this is finalized, we would bring this form to the SANE nurse trainings and then talk to them about, in their area, how they could best access that info.
I think that's right. I think in many situations that might be straightforward, but I can envision some situations where, you know, SANE nurses having to know all that information in their head, it would be challenging. And so I think that's an important thing to identify and to make sure is part of resources that are created to supplement this, and training, as Audrey talked about. That's a great point.
And just to clarify on that, too, it did come forward to say, how does the hospital know what the local law enforcement agency is if they don't question the victim?
If the hospital doesn't, I guess in my understanding, having been on the committee, that information will be gleaned by SANE nurses about where the assault happened. So I guess if that question wasn't asked, it would be very hard to determine that. I'm not an expert on the IAFN protocol, but I think there's some sort of standard information that's gathered by, say, nurses when they're doing a forensic exam, that some of that information, in my understanding, would be gathered. But I mean, I hear your question on if you don't ask it, you don't know it. How can you think about it?
We'll take that to our sane nurse peeps on the committee and just let them know.
Yeah. Right, exactly. Good point. Okay, seeing no further questions on page 1 of the consent form, we are going to move on to page 2, which this is the one that I think maybe I will be very interested in hearing thoughts on how the information that's presented to survivors about delaying to report, so
right.
Option 3, I want to wait. What are some drawbacks of that? And I really want you all to weigh in about how you think this information is presented and how it might be received by survivors. Is something
This page is still a work in progress very much. The first page, I think we have a lot more clarity on because we've worked on it for so long. This second or last section it poses a lot of challenges because at once we want to make sure that victims are completely aware that certain things, when they make this choice, certain things are being sacrificed, or I guess the language would be that there are certain things that will not be able to be done if there is a delay of the report to law enforcement. I'm not committed to this, the way this looks on the page. We're not even committed to much of the content because if you look at it, it's sort of the same things. I mean, the check marks in the first section are what law enforcement could do if you report it right now. The second part is what law enforcement, or what won't happen if you decide to delay. So it's kind of like two sides of the same coin. Much of it might be repetitive. And I should say that the prosecutors and the law enforcement folks obviously on the committee felt very, very strongly that they wanted victims to understand that the case does not get better with age. It gets worse. But that having been said, how do we strike that balance by telling people those things but not overdoing it or, I don't know, showing a balance? And I know that advocates are just so much better at describing these things, so we really didn't want to make an attempt to lay out every single issue that a victim should consider in making this decision, because we know that that's best done by advocates. Person to person really is the best practice there. But so, what's the right balance for this form? I don't think we know yet.
Right.
And we obviously don't. You might need some time to take a look at this and really think about it.
Right.
And it's important to say that Ian continues to attend every single meeting. He's attended every subgroup, every work group that we've had, and he's really your link to the those meetings. So any feedback at any time, or Vicki Bean, can be provided to those two individuals, and they will bring it to us. Obviously, you can tell me too, but
right.
It's just easier and to tell Ian, and
right.
that gives you more time, I guess, to just think about this and let it sit in the back of your brain for a little while.
So I know there's been some chat, and I want to get feedback on this. Just going back to the law enforcement question, there was some chat, right, saying that the location of the assault would equal or
Correct.
Is the law enforcement,
Right.
and that's exactly right. And that, the comment would be that the same, it just went away. Just bear with me. Right, the singer should be asking regarding the location, could contact dispatch and ask what agency covers, what address, et cetera. So that, right, I think that's just confirming what Audrey was saying, right, that the law enforcement is going to be tied to where the assault was. And we will make sure we bring that back to the group to make sure we can make that as easy as possible for sane nurses. I'm guessing there's some, I want to get into the form, but let's take feedback or questions as they're coming in. So.
Okay, so we have 3 comments or questions. 1, would acceptable to present this draft to victims as a draft, only for victim input upon the discharge process at their same visit? Question mark.
I guess I might need some clarification if that's about as a way of getting feedback, or is that about presenting? I'm just a little on. Maybe if there could be a clarifying, if that's like the question is about whether as a way of informing the group.
Feedback only.
I think that, in my opinion, your expertise is so valuable, and you all should be able to collect whatever helps to inform your opinion and your decision and your, I guess, your advice, if you will, on this issue is what you should do. So if you believe that for you to get the best grounding in whether or not this works for survivors, if you feel like you want to share this with some survivors, of course we would ask that you make clear that none of this is set in stone. You know, we don't want anybody upset like, oh, this is already happening and we didn't have any feedback. So we would just ask that one thing, that you make clear that this is a work in progress and that we're just seeking feedback from folks before we put it in place, because of course we don't want to have negative ramifications or impacts later. Right. So I would say do whatever you think is most appropriate and helps inform your opinion, because your opinion is so important to us.
And I think the point on survivor input is really important. Yeah. Something that WCASA is, you know, strategically trying to think about how we can get that as well. Mm-hmm. Because I think the point that the question or the comment is raising is really important.
Yeah.
And we have two just general comments. One, I think it looks good. When advocates discuss pros and cons of reporting, this is what is discussed, and I think having it in writing is helpful. And then also, I feel that this page is not balanced because it does not point out the drawbacks of reporting the sexual assault at this time. Feels like there is a push to the survivors to report at this time.
And I think that I appreciate both comments. I think that second point is something that has been discussed at the committee, and that exact feedback has been shared. And you know, I can certainly understandable about that. You know, the perception that it kind of is weighing heavily on the here's why reporting is good, and here are the drawbacks of not reporting. I think. Right? All of us could identify some potential negatives to engaging with the criminal justice system. You know, how those would be phrased and what that would look like.
Yeah. I mean, I think we recognize the same thing. Where we struggled was in trying to word things like that. So let's say one of the issues is that we all know that when you engage with the criminal justice system, you, by definition, lose some of the control over what's happening to your case, because prosecutors don't represent the victim, they represent the state. I know you guys all know it, but okay, so let's say that argument is one that we wanted to communicate to victims. It's hard to think of a way to word it that wasn't completely offensive to the law enforcement people and the prosecutors at the table, but also that was accurate, but that also did, I don't know. It was tough. So if anyone has suggestions of how to word things, or we did look to other states to see what sort of a chart they might have had. So this, the most of the language you see here is taken from, a little bit modified, but taken from other states' forms. But we really didn't find much in the way of what you're describing. But of course, we're open to hearing any of that. I mean, I agree with the point.
Right, exactly. I think it's something we've been struggling with for a while, that the information is important, I think, to convey about what happens over time. On the other hand, we don't want to put something out there that is, you know, making survivors feel bad about their choice, or feeling like that it's the wrong decision. And I think so. Yeah, thank you for the comment.
Work in progress. Any suggestions? We're asking, we're begging. Any language that you guys have that might work in this context would be most appreciated.
Really helpful. Yeah, and And again, you may need time to formulate that. Certainly not intending that, this is on-the-spot feedback, suggestions only.
Right.
This is, we're putting this out there and encourage, your continued ability to provide feedback, right? Not a one-shot.
Another question.
Yes.
What if someone decides to report as a result of this form, and then the system chooses not to prosecute, and the possible impact of the survivor about the lack of prosecution?
That's a really good point, and I think really important for then that information, like to be, and that's where advocacy is going to be so important here, to understand that reporting, and I think most advocates certainly understand this, right? If we throw this form away, advocates are understanding, can present information to survivors that says, just because you report doesn't mean there's going to be a prosecution. It doesn't mean the offender will be held accountable. And those things are going to depend on the decisions of other actors who the survivor doesn't have control over. Referencing Audrey's point about loss of control, that, to get to the ultimate, right, to hold the offender accountable via the criminal justice system requires, that reporting has to happen, but it doesn't mean those things are going to, those other things down the line will happen, because there's the decisions of others. Prosecutors have discretion about what cases to charge. Juries have decisions about.
Yeah, right. Doesn't mean you're going to get a conviction, even if it's prosecuted. Yeah.
Right. That is so important, and I think in that way, I think those conversations, I would imagine survivors, advocates are having with their clients, with survivors every day, that type of conversation.
The hard part is just to strike the balance. I mean, we don't want to do your job on this form because we know that there are complexities and subtleties, and each person's case is different. What that person needs to hear or needs to understand or needs explained to them is something that you can gauge as an advocate when you are with them. So we didn't want to try to do your job here and set forth every single thing, but at the same time we don't want it to be completely lopsided either. It's a challenge.
Right, and I think, back to the point, I think the question or the comment was, I think, conveying information about, you're reporting, these things may happen, but they may not. And I think, putting on, your advocacy hats and going through those pros and cons with your clients about, what happens if the worst case happens? How would you feel about it? I mean, those are core advocacy concepts. And again, I agree with Audrey. This was not meant to spell out how to do your job, but I think it reinforces the importance of advocacy and the role advocates play in providing a breadth of information for survivors to make the best choice they can.
I'm making notes right now of everything that you all are bringing up, and we will definitely address those at the meeting and with the drafting of the next draft of the consent form.
And, that this is a draft. Okay. So moving on, we've been in discussion time, obviously, so we can continue to take comments. There's a couple of questions I wanted to ask as far as like a polling type question. So I don't know if they need specific, I'm sorry, you can type that, the answer in the question box.
Okay.
So the first question would be, for a sexual assault survivor who is uncertain about reporting to law enforcement, is it beneficial to have the crime lab store the rape kit for 6 years to give her or him time to decide about reporting? And you can just type yes or no, your feeling.
I'm going to give everyone about 10, 15 seconds to type, and then I'll read back all the responses. All right. There might be some folks writing longer answers, but as of right now, we have 6 yeses, 1 followed by yes, it is beneficial, 7 yeses.
Okay. Thank you all. Now this one is a little wordy, and I, apologize. We got the lawyer writing the question.
Trouble.
But I'm trying. Hopefully you all understand what I'm trying to get at. And again, thinking about we're in option 3. So for that sexual assault survivor who's uncertain, does the proposed consent form present information? I'm really thinking about almost more page 1 here, because I think page 2 is harder to get as a yes/no. About what will happen to the rape kit and the victim's information in a way that is understandable. So I'm really looking at, oops, sorry, I'm moving the page 1, hoping the question is clear, but really focusing on what happens to the kit, storage, and what about the victim's information.
All right, so we have someone who says, yes, I like it in writing, something they can keep, be informed, and make an informed decision.
Okay. Well, we've talked about page 2, and if there are other feedback either now or in the future, just please again feel free to convey that. I think there's my contact information. Just as one final point, this was not something that the issue that I want to bring up now relates to something that's been in the news fairly widely, was about the number of untested kits in Wisconsin. That number really comes directly from the AG SART. I mean, that was the product of work done by the AG SART. But and the subcommittee hasn't even met yet for the first time, and that's going to be happening at the end of the month. But I think what we'll need to be thinking about, and where I'm interested to hear from advocacy groups and survivors would be, for those untested kits, that are going to be tested. I mean, the committee has to develop a protocol and procedure for how those kits are going to be tested, et cetera. When do you do victim notification on that? And I'm not imagining you all will have the answer. And when you look at nationally, it seems to be a patchwork of you notify the victim before you test, or maybe you only do it after, or unless there's a hit. So the kit would be tested, and you're only going back to the victim if there's a positive identification. That's something I think we need to think about from a victim's perspective on, that victim may be at a very different place now or, after the test than they were, when the kit was collected, and how to do that in a victim-centered way. I know that the Joyful Heart Foundation, which is one of the national groups who's kind of doing some advocacy around that, they're releasing I think a document, but maybe it's now not coming out till the end of the year. And other states have made different decisions. But I'd be interested in your thoughts and feedback, either again now, if you have anything via chat, or down the road, and recognize you probably will be hearing more about that issue in future months. Any final words, Audrey?
No, I just want to say thank you to you, Ian, and to WCASA for Olive and Vicki Bean, and just for all the hard work that you've done so far, and that I know we're still going to do. We really appreciate it.
And I want to thank all of you for participating, for your feedback, your thoughts, your questions. We really appreciate that. It helps inform the work, and like I said, this is a work in progress. And stay tuned for more information coming down in future months, and know that you have the ability to provide that input going forward. So thank you. Oh, I think we have one.
Okay. Some quick questions from two different folks.
Okay.
How will we receive the webinar materials? Anything in Dropbox? Just my opinion, but it'd be very helpful to have them in hand.
Absolutely. Well, we can send them out via email.
Okay. So a follow-up email will be sent with that, and then two people also just saying thank you and thanks for all you do.
Great. Thank you all, and I hope you have an enjoyable rest of your day and week, and thanks again for participating.